Prosecutors in the Eastern District of Virginia may have an uphill battle ahead of them after former FBI Director James Comey pleaded not guilty to their charges, as we expected him to, alleging he lied to Congress. And so far, the wheels seem to have already started coming off. I mean, at one point today, Comey's attorney, Patrick Fitzgerald, says he didn't receive a draft of a key discovery order from prosecutors until 11 p.m. last night, with Fitzgerald adding, "I confess, I was asleep." And then there's the star of the prosecution show, interim U.S. Attorney Lindsay Halligan. Let me read to you everything she said in today's hearing. I'll read you the whole thing. Lindsay Halligan. That's it. She said her own name at the start of the hearing and then nothing else. Nailed it. Crushed it. Joining us now to talk about all of this is Preet Bharara, former U.S. Attorney for the Southern District of New York. Preet, so much is happening at the same time, and I want to ask you about the big picture here, but I just want to start with a couple of things about today and the specifics of what's happening with Comey and the path forward. I mean, his defense attorney said he plans to file... Oh, great to see you, too. His defense attorney said he plans to file motions both for vindictive prosecution and to disqualify Lindsay Halligan's appointment as U.S. Attorney. Help us understand what the path is for those, how likely they are to succeed. What does it look like? What should we understand about it?
Yeah, so these are motions that almost never succeed. The history of these, excuse me, the history of these motions' success historically is very, very low. But they're available in extreme circumstances. And I think a lot of people would say that if there were ever a circumstance in which they might work, it might be this one. And we have a precedent for it already. In a completely different context, in a completely different case, the case of Mr. Abrego Garcia that people may be familiar with, there was a motion made by defense counsel, not for outright dismissal on these grounds, but to get discovery and to get more information to learn whether or not the prosecution was brought not in good faith because a crime was committed, but to punish or to be punitive towards a defendant who was exercising his rights. And that motion was granted for discovery. So here you have a long record of the President of the United States who claims to be a part of the unitary executive, who says that he has every right to direct prosecutors under him, including the Attorney General of the United States, to investigate and prosecute and imprison people who he doesn't like if he wants to. There's a long record of him saying that he doesn't like Jim Comey, saying that Jim Comey is a traitor, saying that Jim Comey should be in prison. And if the answer to those questions is that the defense lawyers will ask, is that the reason why the case was brought, vindictively and maliciously? Well, that's a basis to dismiss the indictment altogether. And that motion, I think, is going to be quite strong based on the evidence we have so far.
Do you think, well, let me ask you about one specific thing that broke just right before the show, because, and this isn't really a surprise. I mean, the Truth Social post where Donald Trump is sort of directing Pam Bondi to go after Comey, saying nothing is being done, what about Comey? It turns out was meant to be a direct message. Does that matter in terms of from the legal? So how does it matter? Help us understand that.
So I think that's a big problem, legally and substantively. For the Department of Justice and for the president. As we said, not just Jim Comey, not just Mr. Abrego Garcia, but other people who are in the crosshairs of the president, various elected members that have been talked about on this show, will have viable motions to dismiss indictments if they come in the future on the basis of vindictiveness. And to the extent that there are public statements that we have heard about, that's powerful evidence. But if it's the case that this message that you're describing was meant to be a direct message, a private message, I will bet you everything that I have that that wasn't the only one. That there's a course of dealing, there's a course of correspondence between the President of the United States, the Attorney General, maybe other people in the Department of Justice, maybe individual U.S. attorneys and other cabinet officials that will bear light on the question of the vindictiveness of the prosecution. And so if you get those things in discovery, which I think at a minimum will be granted in the Comey case, as it was granted in the Abrego Garcia case, that's very, very bad for the prosecution. On the other hand, even worse perhaps, if those communications took place but were not preserved, and hypothetically, I think good lawyers will have already asked for those communications to have been preserved in anticipation of this litigation. If they have not been, if they have been destroyed, that is a terrible look for the president and the people who work for him. And it also gives rise to an adverse inference about what's in those communications. And there is an argument that those communications and the destruction thereof by themselves are a basis to dismiss an indictment.
That's such an interesting point, and I hadn't thought of that. I mean, the DMs, there's no way this was the only DM, just like it wasn't the only signal chat among national security officials. And so if you're the lawyers or any good reporter, you're looking for that information for different reasons. Do you think, I mean, this is supposed to go to trial in January. Do you think it gets there?
I don't think it gets there. And there's a part of Jim Comey, based on what he said in his Instagram post, that wants to have a trial. He said, let's have a trial. But there have been so many errors. There's so much evidence of vindictiveness and selective prosecution and other problems that I don't think it gets to trial. By the way, we were talking earlier about how some of these new prosecutors, may not be well versed in the case. It's hard to blame. It's hard to blame them for that because they're new to the case. On the other hand, so that's on one hand. On the other hand, you kind of wonder how it can be that new prosecutors, knowing that very, very seasoned, experienced prosecutors who were on the ground level of the investigation, who looked at the facts, who interviewed witnesses, who looked at documents, and were well-versed in the case, thought it should not go forward. So to decide to go forward and insert yourself from another district, in this case, not knowing all the facts is odd to me, and we'll see how that plays out.
Preet Bharara, thank you, as always, for giving us a lot to think about. Better understanding of the law without a law degree, as always. Thank you again.